Okay, sounds good. Thanks, Mel.
Okay, we're good. Um, Thank you for joining everyone that's here. Today we are doing the Expunction Clinic, and today that will be presented by Lorena and Ryan. So I'll just go ahead and turn them over to those guys without any further ado. Thank you so much for being here. I appreciate it.
Thanks, Mel. Let me just get this set up. Hopefully, can you see my screen, Ryan?
Yes.
Okay, perfect. Like, I don't slideshow. That would be good. Okay, great.
Yeah. It always screws me up too.
Okay, great. And I also can't like see the Zoom screen now, so I'm just gonna like go with the flow, and then, you know, if anything pops up in the Zoom, you just can address it if you're able to, Ryan.
Yeah, that when we get to the questions, you can just minimize your screen. It should stay up for everybody, but if not, oh well.
Okay. Oh, I think I clicked stop sharing. Can you see my screen?
I cannot at the moment.
Sorry about this, everybody. Ha ha ha.
Everybody's used to Zoom meetings. There's always a learning curve.
I'm like, what? Okay, can we see it now again?
Yes. No matter how many times you do them, always a learning curve.
I know. Okay, thanks. I appreciate it. Hey, everyone. I hope everyone's doing well today. I'm here. My name's Lorena Grizzett, along with Ryan Francis, and we're going to walk you through expunction law in North Carolina, give you some information about expunctions and kind of the process in which to obtain an expunction, as well as requirements, eligibility, and whatnot. We just want to briefly start by saying, I'm just going to give information. There will be an opportunity at the end to ask some questions. We'll say if you can keep them vague, that would probably be best to eliminate sharing any personal information. If you are wanting to know about, you know, specifically about what your eligibility might be, we can walk through at the end how you can apply for legal aid. And if you're eligible for our services, hopefully be able to get in touch with us, and we hopefully would be able to give you some more pointed advice information about what eligibility might look like for you in your particular circumstance. And so just to start with a little information about legal aid, we are a statewide nonprofit law firm that provides free legal services and civil matters to low-income people in order to ensure.
Aren't changing, Lorena.
Oh, they're not?
No, I don't think the presentation mode's active yet.
How do I do that?
It should be. You did it the first time.
From beginning in the top left, do you see that?
Yeah, I did that, and now is it working now?
No, I might be behind something. You're using like two monitors. You might have to change which monitor you're sharing.
I'm only using one.
It might be. Did it open a new window when you started the presentation?
I think so.
Yeah, so switch it to share that window that it opened, the new one.
Okay. Sorry, everybody.
I don't know that this is the solution. I am just guessing.
What if I do this?
That's the PowerPoint.
Yep. Is it working now?
We don't see the presentation mode. Like we're
Ryan,
looking at.
You might want to do it because I don't know why it's not showing.
Because it's showing. So I see your mouse moving.
I don't know why it's not showing to you. I think I'm doing it right, but I guess not.
Okay, when you share, are you pressing like the top left, it just says screen?
What about this?
Oh, that's perfect. That's it.
Perfect.
Fantastic. Sorry, everybody, for the technological difficulties.
All good, all good. Just getting the kinks solved early. It's all good.
Yeah.
I didn't even open it. I had faith.
Not the best technology, but what I can give you is legal information about expunctions. But first, just a little bit about legal aid. We are a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. The list below is the areas of practice that legal aid works in: employment, housing, education, domestic violence, disaster relief, consumer, as well as expunction relief. Additionally, along with this monthly clinic, legal aid also holds monthly clinics for child custody and visitation, employee rights, healthcare power of attorney and living wills, simple divorce, social security disability, as well as tenants' rights. And you can sign up for those clinics via our website. If you are watching this and you think you might want to learn more about any of these areas of law, you can feel free to sign up for any of the upcoming clinics. Okay, passing it to Brian.
All right, so I'll start us off here. What is an expunction? Seems like a good place to start. So in North Carolina, a person's criminal record is made up of charges and convictions separately. So this means that even if you had a case dismissed or you were found not guilty during like a trial, the fact you were charged to begin with remains on your permanent record. So an expunction simply clears that charge or conviction from your record. If granted, the information is simply gone. And you can truthfully say after that that the charge or conviction never occurred, within a couple of exceptions. So there are some jobs where you'd still be required to disclose whether you've had an expunction. These would generally be things that are like in the military or require a security clearance or a position in like the federal government. Next slide, please. So by virtue of you all attending this, you are aware of why expunctions are so important. So I'm not really going to say much on this slide, but I do want to clarify one thing that comes up a lot. Expunctions are granted by the states. So North Carolina is only able to grant expunction of charges and convictions that occurred in North Carolina. So what we're talking about today is just discussing that specific process, the North Carolina process. Other states will handle the eligibility, what you can expunge, and how you go about expunging it differently than North Carolina does. Our attorneys are licensed in North Carolina. This is the only state that we can advise on. Next, please. All right, so what is eligible for an expunction? The specific offenses that you can expunge in North Carolina are defined in the expunction statutes, along with the specific requirements for each one of those expunctions. And when I say specific, I mean very specific. Expunction law doesn't have a whole lot of wiggle room to it. You essentially just look at the statute and you either are going to qualify for an expunction or you are not. The type of offenses that can be expunged are actually a pretty wide range. They do include dismissed charges, charges found not guilty, not responsible, certain misdemeanor convictions, and certain felony convictions. And we'll go over what that means more as the presentation continues. In general, violent offenses are not eligible for expunction at all, unless the offense occurred under the age of 18. Although it's worth noting that what is considered violent is defined in each one of the expunction statutes, and it does change a little bit from statute to statute. All right, so the first type of expunction we are going to discuss in more detail here is also by far the most common type that we see. This allows a person to expunge any and all misdemeanor and felony charges that were ultimately dismissed or there was a finding of not guilty or not responsible. So a few years ago, the Second Chance Act greatly expanded the eligibility for who can receive this type of expunction by removing a requirement that there be no felony conviction on that person's record. That was a pretty limiting requirement, so we're very excited that that is now gone. There's also no waiting period for this type of expunction or required hearing or limit on the number of times a person can be granted this expunction in a lifetime. Being granted the expunction is mandatory in a situation where all the charges in a case have been dismissed or were found not guilty. And mandatory simply means that a judge does not have any discretion. If you qualify for that expunction, it must be granted by the court. In situations where one or more charges resulted in a conviction, and then in that same court session, there was also dismissals, those expunctions are not considered mandatory. A judge does have a final say in whether or not it gets granted. And I believe next we have some dismissed charge examples. Yes, we do. All right, so example one here, we have someone who was charged with manslaughter and the charge was ultimately dismissed. Manslaughter is, of course, a violent offense, but because it was dismissed, it is eligible for expunction immediately with no waiting period. In example two, we have somebody who was charged with two offenses: possession of marijuana, less than 1/2 ounce, and possession of drug paraphernalia. They were ultimately convicted of the possession of drug paraphernalia, but not the marijuana possession. So in this case, this expunction would ultimately be up to a judge whether or not it's granted, but expunction of the possession of marijuana would be immediately eligible. Then we jump to example 3 here, and we've got somebody who was charged with felony larceny by an employee and was ultimately found not guilty at trial. That can, even though it is a felony, can also be immediately expunged. All right, I believe I'm passing it to Lorena now.
Awesome. Thanks, Ryan. So the next type of expunction that we're going to discuss is raise the age relief. And this kind of relief allows the expunction of all misdemeanors and class H or I felonies that were committed before December 1st, 2019 by 16 and 17-year-olds. So if someone committed any kind of misdemeanor or a class H or I felony before December 1st, 2019, and they were 16 or 17 at the time of offense, they may be eligible for raise the age. I will say there are 2 pretty important exceptions to this. If someone, even if it was before December 1st, 2019, and they were 16 or 17, if they were convicted of motor vehicle offenses or any kind of offense that requires sex offender registration, those kind of offenses, convictions are not eligible for raise the age. Is there a cost to file? Yes, usually there is a $175 filing fee. However, there is a petition known as a petition to proceed as an indigent that may allow the court and the clerk to waive that fee. Requirements, besides it being any kind of misdemeanor or a class H or I felony, and it was committed before December 1st, 2019 by someone who is 16 or 17 at the time of the offense, as long as that individual has completely finished their sentence, whether that was any kind of active jail time, probation, post-release, payment of restitution, or any civil judgments, as long as all of that has been completed, as long as that has been done, that particular offense conviction that is eligible for raise the age becomes eligible at that point. So besides completing and finishing a sentence, there's no other kind of waiting period for raise the age, as it states in the other considerations. No barrier to relief. So if someone qualifies to raise the age, that doesn't disqualify them from potentially expunging any other eligible convictions, like any adult convictions someone may have. There's no limit on the number of convictions or expunctions under this particular kind of expunction relief, and relief is mandatory. So like Ryan just briefly stated, if someone fits all of the requirements, the judge doesn't have any discretion in terms of whether to grant this kind of relief. This slide has a fancy transition. And so some examples to kind of illustrate how this kind of expunction works. 2004, Monica was 17. She was convicted of simple assault. The following year, after she turned 18, she was convicted of communicating threats and second-degree trespass. And then she was subsequently sentenced to 45 days in jail. Monica's assault conviction, although had she been convicted as an adult, which we'll get into, wouldn't be eligible because she was 17 at the age in which she committed that and was convicted. That is eligible for expunction, and also subsequently would not prevent her from potentially expunging those communicating threats and second-degree trespass if those were eligible and she completed the requisite time waiting period, as we'll get into. In October 2007, Trevor is 16 and he's convicted of 5 counts of felony larceny by an employee. In November 2008, he is convicted of 2 counts of assault on a female. He completed his sentence in November 2009. All of Trevor's charges are eligible for expunction because he was 16 or 17 at the time of the offense. For this example, felony larceny by an employee is typically a class H felony, and class H or I felonies are eligible for this kind of relief under raise the age, as long as it's not a motor vehicle offense or an offense that requires sex offender registration. And then assault on a female is a class A1, under raise the age. All classes of misdemeanors, as long as it fits the raise the age requirements, are eligible for relief. Couple more. July 2016, Marsha is 17 and convicted of felony breaking and entering. She pays off her restitution in 2021. It is expungible. When she committed it, she was 17, even though she didn't pay off her restitution until 2021. Assuming that, you know, that was her finishing her sentence. It's a class H felony. She can expunge it under raised age. Remember this for later. November 2018, Brent is 17 and he's convicted of a DWI and a felony flee to elude arrest. He completed his sentence in January 2020. I kind of spoiled the fun here. These are not eligible for expunction, even though he was under the age of 18, because they are motor vehicle offenses. So while it's great that he completed his sentence, unfortunately, he still cannot expunge it under raised age. Okay, so now we're going to get to expunction of adult nonviolent misdemeanors and felonies. Ooh. And so current categories that allow for the expunction are one nonviolent misdemeanor conviction after 5 years. And these are broad picture. We'll get into the more specific for each one in a couple more slides, but one nonviolent misdemeanor conviction after 5 years, multiple nonviolent misdemeanor convictions after 7 years, one nonviolent felony conviction after 10 years, and up to 3 nonviolent felony convictions after 20 years. However, a little caveat with that, up to 3 nonviolent felonies is that those 3 felonies, up to 3 felonies, must have occurred within the same 24-month period, aka the same 2 years, in order for that individual to qualify for that kind of expunction. And so we keep mentioning, you know, violent offenses versus non-violent, and we frame it that way because that's kind of how the statute is written. And so essentially, this is just a lot of words pulled directly from the statute. But the most important thing to know is that if someone has any one of these considered disqualifying convictions, they are not eligible to expunge any of their adult convictions. So if someone is eligible for raise the age, they're still eligible to do that, and any dismissals that they may have, not guilties, not responsibles. However, if someone has any one of these disqualifying considered violent convictions, that unfortunately bars them from being able to expunge any of their adult convictions. So for the purposes of expunction, the term nonviolent misdemeanor or nonviolent felony means any misdemeanor or felony except the following. And so if someone has any class A through G felony or any class A1 misdemeanor, any offense that includes assault as an essential element of that offense, any offense that requires sex offender registration, whether or not that person is currently required to register at that time, any kind of stalking or sex-related offenses, felony possession with intent to sell, deliver, or felony sell and deliver cocaine, felonies that involve methamphetamines or heroin, any convictions that are involving any kind of racial intimidation, such as like cross-burning, any offenses committed because of the victim's race, color, religion, nationality, country of origin, any convictions that involve contaminating food or drink to render someone incapacitated or helpless, felony breaking and or entering. However, felony breaking and entering can get a little tricky. There are a few kind of caveats with that. Any felony offenses that include a commercial motor vehicle, and essentially the last one is just a roundabout, essentially an attempt to commit any of the above offenses. So if you are convicted of an attempted class A felony, that would be considered a disqualifying conviction. Essentially, just to say if that someone has one of these kind of convictions on their record, they're ineligible for any adult relief in terms of any other convictions that they might have. I think it's you now, Ryan.
Okay, so we're going to go back down and talk in a little bit more detail about the single nonviolent misdemeanor conviction. So As it sounds, this allows you to expunge a single nonviolent misdemeanor conviction that occurred at any age. So you would use this expunction if you were over 18 at the time that the offense was committed. If there are multiple nonviolent misdemeanor convictions that occurred in the same court session, so that you're charged with on the same day, then they can be treated as a single conviction for the purposes of this expunction. So this is like if you were charged with 15 counts of felony food stamp fraud, and they all occurred in the same day, that would count as one conviction for the purposes. Well, okay, I said felony. I messed that up. I meant to say misdemeanor. Misdemeanor food stamp fraud. And they all occurred on the same day. Then for the purposes of this expunction, they would count as a single conviction. So to qualify, a person must have no other felony or misdemeanor conviction on their record other than traffic offenses. And when we say traffic offenses throughout this, what we're referring to is any offense that is a misdemeanor level in the statutes. It's chapter 20. This is the traffic chapter in the statutes. So this would be like speeding. All of your minor traffic offenses would be included here. They must owe no outstanding money or restitution. And 5 years must have passed from the date of conviction or from the completion of the sentence, whichever is later, and that does include probation. For this expunction, relief is mandatory, which again simply means if you meet the requirements, the court must grant the expunction. And there is a $175 filing fee with this expunction, though that can also be waived, as we'll mention again later. All right, so for multiple nonviolent misdemeanor convictions, so this would be convictions occurring on different court dates. So the requirements for this are that it must have been more than 7 years since the date of completion of whatever the most recent conviction is. None of the offenses are considered violent, like Lorena was just talking about. And there's no outstanding money or restitution owed. And then like the last expunction we discussed, relief is mandatory, and there's also a $175 filing fee. And then back to you.
So I'm going to discuss, as it states, single nonviolent felony convictions, just as kind of Ryan explained with the single nonviolent misdemeanor. Multiple convictions in the same court session are counted as one single one for the purposes of expunction. And so if you were convicted of 3 felonies on the same session of court, that can be considered one for the purposes of an expunction. Now the requirements, more specifically, 10 years must have passed from the date of conviction, or 10 years from, the completion of any active sentence, probation, or anything that someone may have, whichever is later. Again, no conviction for anything considered violent. The only difference, well, not only difference, but one of the big differences between misdemeanor relief and felony relief is that relief is discretionary, meaning that, the judge has wiggle room to, weigh someone's complete story and make a determination based on kind of the weight of the evidence, so to speak, kind of look at it holistically and make a decision based on that. However, if a judge does use their discretion, usually on the petition, there is a space for them to detail why they did not grant the expunction and kind of give a reason as to why, even if someone fits all of these requirements, why they're not going to grant the order for the relief. Again, the cost is $175, but that can be waived if needed. And then up to 3 nonviolent felony convictions. This allows for the expunction of up to 3 nonviolent felony convictions. Again, with the caveat that those 3 felony convictions occurred within the same 24-month period, same 2 years. If someone has 3 nonviolent felonies that occurred within 2 years, then they may be able to petition for all of them to be expunged under this expunction statute. Again, multiple convictions on the same session of court can count as one. And so the requirements, the time frame here, the waiting period is 20 years, at least 20 years from the most recent conviction, or 20 years since the completion of any active sentence, probation or post-release, whatever is later. Again, no conviction for anything violent. The cost is $175. Again, that can be waived, as well as the relief is discretionary. Some things to know is that DWIs used to be considered a disqualifying violent offense. However, the statute was changed. DWIs are no longer a disqualifying offense. Formerly, if someone had a single DWI, that prevented them from being able to expunge any of their adult convictions. That's no longer the case. However, a DWI itself cannot be expunged, but it is no longer a bar to relief if someone has eligible convictions besides the DWI. Like I said, breaking, entering, expanded eligibility, that's one that often needs a closer look at depending on what exactly the breaking and entering was. There used to be automatic expunctions. That has stopped as of August 1st of this year, and it is going to be stopped for about a year. And so essentially, just if anyone has any dismissals, acquittals from August 1st, they would need to actually petition for those to be expunged. Whereas since I think December of last year up until August of this year, August 1st, if someone had gotten a dismissal in between that time, the court was kind of expunging it at that point, and the individual wasn't needing to petition for it, but that has stopped. And so now individuals are going back to having to petition, fill out the petition in order for those to be expunged. One important thing to note is that if someone has multiple qualifying adult convictions that are eligible to be expunged in different counties, by statute, there is a 120-day kind of timeline by which that individual needs to have filed every single petition in every single county for every single eligible conviction that they have. Because unlike dismissals, acquittals, and raise the age, when it comes to expunging adult nonviolent convictions, it's kind of one bite at the apple, so to speak. And so an individual has one chance, one time to petition for all of their eligible adult convictions. And so this 120-day rule gives someone 120 days to essentially petition in multiple counties all of their eligible adult convictions, because if someone misses a petition in one county for an eligible adult conviction, if the 120 days has passed since the filing of the first petition, ultimately that person has waived their right to expunge that conviction that they missed, essentially. And so that can be important if someone has multiple eligible adult convictions in multiple counties. Am I going through the examples, Ryan?
Yes, I believe so.
Okay, sorry, thanks. Just wanted to make sure. And so Felicia was convicted of misdemeanor
If not,
larceny.
I can make it up as we go.
No, you're fine. I got it. Misdemeanor larceny, possession of stolen goods, and possession of drug paraphernalia on November 3rd, 2015. Important thing to note here is that she was convicted of all of these misdemeanors on the same date. Because of that, they all count as one. The waiting period for her would be the 5 years, along with all of the other requirements. Seth was convicted for resisting a public officer in 2014 and for 3 counts of disorderly conduct in 2015. Since Seth's convictions took place during 2 separate sessions of court, he would go to the multiple nonviolent misdemeanor requirements, and the waiting period for that is 7 years. Lizzie was convicted for hit and run, communicating threats, and DWI on June 6, 2018. A year later, she was charged with second-degree trespass and harassing phone calls, but those charges were ultimately dismissed. Lizzie's convictions for the hit and run and communicating threats can be counted as one because she was convicted on the same day. And so those would be eligible for expunction, under the one single nonviolent misdemeanor requirements. The waiting period would be 5 years. Even though she was also convicted of that DWI, while she cannot expunge that DWI, the DWI does not bar her from petitioning to expunge the eligible convictions, given that she meets all of the requirements. And again, those other 2 charges were dismissed, and so those become eligible immediately once they have that dismissal. I think you're up, Brian.
All right. So now I'm going to fairly briefly talk about the process of actually filing for an expunction. So the first step would be to obtain or to determine exactly what type of relief you are actually eligible for to begin with. So in order to do this, you need to obtain a complete copy of your criminal record. Criminal records can be obtained through the clerk of court's office in each county, through a request to the SBI, or from public terminals in each of the courthouses that you can access. Once the record's been looked at and the type of expunction that you're eligible for has been determined, North Carolina uses a petition process in order to request the expunction, which Lorena has mentioned a couple times. Each type of expunction that we've gone over and the other types have their own specific petition that needs to be completed. The petitions are available online through the NC Courts website. Many types of expunctions also have additional documentation that needs to be submitted. That includes witness affidavits and notarized statements. The petition needs to be filed at the clerk of court's office in the county in which the offense that's going to be expunged occurred. So if there's a misdemeanor larceny conviction in Wake County, you're going to be filing the expunction petition to get rid of that in Wake County as well. Each county has their own specific rules for how they actually go about filing the petitions. So we always highly recommend contacting the relevant clerk of court's office before going to file, just to make sure that you're following any local rules that might be in place. In situations where petitions must be filed in multiple counties, as Lorena mentioned, they all must be filed at their relevant clerk's office within a 120-day period. In general, once the petitions have been filed, it takes 3 to 4 months for an expunction to be granted. Once notice is received in the mail that the expunction has been granted, we always say that it's a good idea to actually go check your record again just to verify that everything was actually properly expunged. Next, please.
Mm-hmm.
All right, so some of the recent changes to expunction law have created a couple very limited instances where access to expunged records is allowed to be granted. Those situations are prosecutors are allowed access to expunged records only in the sentencing phase. So only to calculate a new sentence after a conviction's occurred, or for determining habitual offender status, which is again a status that's used in sentencing. Arresting agencies like police departments, they're allowed to maintain investigative records that may be related to an expunged charge. So essentially, this requirement is just making it so they don't have to, go through and clear out all their investigative paperwork every time there's an expunction. And then finally, law enforcement is allowed access to expunged records for their own employment and certification purposes. And I believe currently that is the only instances in which access to expunged records is allowed. Sorry, I screwed you up there, made you go back.
No, you're fine. I didn't want to cut you off if you hadn't finished. And so that is potentially a different kind of relief known as a certificate of relief. This is not an expunction, but it can be beneficial to a lot of individuals who might not be eligible for an expunction to obtain some kind of relief from that particular convictions, even though it's not going to be removed from their record. And so it can be obtained for any kind and any number of misdemeanors, but for no more than 3 HRI felony convictions. It can provide significant relief. It can allow for opportunity for discretion for automatic exclusions, meaning that if you were to apply for something and they were to look and they would automatically exclude you from applying or moving forward because of your record. If someone has a certificate of relief, it can allow that agency individual to use their discretion whether to proceed, despite whatever might be on your record. It should be viewed favorably in any kind of discretionary decisions. So if someone has a certificate of relief, there's discretion to be made. A certificate of relief should be viewed favorably for that individual if they have one. It can also help when it comes to employment and housing opportunities in kind of 2 different ways. One, it can improve an individual's housing and employment opportunities because it can offer an employer kind of protection from negligent hiring liability because of someone's record. Additionally, it can also offer a landlord protection from negligent leasing liability because of someone's record. And so a certificate of relief is a possible option for individuals who might not qualify for an expunction, but would like some kind of relief to help them in these kinds of areas. Now, for some closing thoughts, as Ryan briefly mentioned when he walked through the process of, obtaining an expunction, North Carolina has 100 different counties that handle expunctions in slightly different ways. And so ultimately, if someone is proceeding with the expunction process, as Ryan said, we always recommend that they call that local clerk of court just to ask, let them know, hey, I'm wanting to go through this process. What does that look like in this courthouse? Because they're usually the individuals that are going to know how that process works. As stated, would contact them always for any questions prior to filing about what you would need to do to make sure that that individual is doing everything that they need to in order to kind of complete the process, make sure hopefully that it goes without any potential issues, hiccups, anything like that. And if someone wants to proceed, go that way, contact information for the clerk's offices can be found online on our website, as well as nccourts.gov, I think. That has every county in North Carolina. You can click on it, get the clerk's office. If you need the DA's office, get that information so that you have access to kind of reach out to who you need to reach out to. So those are all of the vast information about expunction law that we have to give you all today. As I said, now we can go into answering any questions, and here online or calling the helpline if you are interested in potentially seeing if you're eligible for legal aid assistance and seeing if you might be able to get some assistance with potentially seeing what your options are in terms of expunctions. You can feel free to apply online or call the helpline, and we hopefully will be able to get to you and kind of start that if we're able to. So I am gonna exit and stop sharing my screen. And maybe we have some questions. Maybe not.
I'll be real, I wasn't looking at the chat. I don't see anything though.
I don't see any questions, but I don't know if there's any on the Facebook. If anyone has any questions, feel free to put it in the Q&A and we'll try to address it as best as we can. I don't know if Niall can hear me, but I guess if he wants to look on the Facebook. Okay. So first question we have is, how does someone start the process as soon as possible?
Sorry, there's nothing on Facebook. I just checked.
Okay, that's fine. Thank you, Niall. And so I think, it really depends. Like if someone wanted to go today, if they had all of their records and kind of go that way, there are a lot of moving different factors in terms of like timelines and how long this process can take beginning to end. If you were wanting to see if you could get some assistance from legal aid, I would say go online, apply, call the helpline. It can take a little time for us to kind of reach out back to you to kind of follow up in terms of pulling your record, reviewing it, determining eligibility, confirming it with somebody to make sure that everything is what we should be finding, if we're missing anything, because that can be important in terms of, especially when it comes to adult convictions, we want to make sure, someone wants to make sure that everything that should be there is there, because you don't want to potentially miss the chance to expunge an eligible conviction. And I don't know, that's probably, if you wanted to reach out to legal aid, probably the best way is to do it online. And that can take a little time for us to get to you. But if you apply, someone should be reaching out to you at least within 4 to 6 weeks. I think that's pretty.
If you wanted to start the process absolutely as soon as possible, I would say contact a defense attorney in the area and they can start it immediately. You can also start the process yourself, but we really don't recommend that unless it's like your only option, just because the forms and the process itself can be finicky.
Mm-hmm.
It's not like you can do yourself any harm by trying to do it yourself, but you can waste a bunch of your time and frustrate yourself with the forms. So Sorry, that was all I was adding.
No, that's true. Next question, how long is the expungement process? Again, I think that can vary. That can definitely vary county to county in terms of once someone has like filed a petition. I think that varies. And it's really kind of a waiting game, I guess, but once it's filed at least. Okay.
I guess I could slightly expand there. There is one county that shall not be named where they literally only look at their expunction petitions one day a month. So if you filed your petition on like the 10th in this county, they're not even going to look at it until the 9th of the next month. So
Right.
like Loretta said, it can vary by county.
How long, I guess that's the same kind of, how long does it take to be removed? I mean, once a petition is granted, I don't know how long, Ryan, would you say, I guess, for at least, I guess.
I usually say 3 to 4 months at the moment. And then at that point, go and check your record again, make sure it's actually gone. It's substantially faster than it was a few like years ago, because we used to tell people to give it a full year. So it's improving at least.
That's one good thing. Someone says, how do I start, and do we help with the whole process? If you were wanting to see if legal aid could assist you, kind of how that would go is you would call the helpline, apply online, speak to an intake specialist who would kind of get all of the information that we would need. In terms of eligibility, I mean, just legal aid as a whole has certain like financial eligibility requirements. And so you would have to fit within those in order to be able to kind of proceed. But at that point, you know, if you were eligible and someone's file was to be assigned to an attorney, you know, that process is we would pull a record, confirm it with you, kind of determine eligibility. And most often than not, you know, once we've confirmed, walked through eligibility, would draft the petitions for you, and then just highlight where someone would need to fill out their personal information, sign it, and then also walk through how someone may want to go about filing them, and kind of walking them through that process. So that tends to be kind of how we can assist in terms of drafting petitions, sending them out to clients. For the individual, most of the time to file themselves, recommend calling that clerk's office and kind of walking through what they would need to do on their end to make sure that it got filed. And then, as we keep saying, once someone's filed it, in terms of how long it would take to get an order back, whether it was granting or denying, that can vary county to county. I don't know if you have anything to add to that, Ryan.
No, not to that. I see we do have a cocaine question coming up though.
Okay, I'll ask the question. Someone says, who do you contact to get started? LegalAidNC.org also has our numbers on there if you wanted to call the helpline, but that's where you can go to apply online if you wanted to see about potentially getting legal aid assistance. Okay, so if I have a possession of cocaine, would I have to wait 10 years?
Cocaine is weird in these statutes. It's going to just depend very specifically on how you were charged. So that would be a situation where anybody would have to look at your record in detail to give you the answer to that one. That's definitely one that I would highly recommend contacting our office over.
Next one says, if I have a dismissed felony for an assault, could I get that expunged? The key word in there is it was dismissed. And so assuming that it was dismissed without leave, yes. Any charge that someone has that was dismissed is eligible for an expunction, even if it's an assault, or even if it was a conviction, have been a disqualifying offense. Where do you get the petitions? You can find them, I think it is NC Courts.
I think you are correct. I'm pretty sure it's .gov, although .org also just redirects you to.
It does? Okay, I didn't know that. That's good to know though. I didn't know that, but
I'm like 99% sure you are correct, though. I believe I misspoke.
I think the only reason is I think I've made that mistake many a times. But nccourts.gov has pretty much every single kind of form that someone may need to file something. So you can find all of the petitions depending on, like Ryan said earlier, there are different petitions for the different kinds of expunctions. So you can find all of them on nccourts.gov though, or .org, whichever one you feel like typing in. May get you there.
To be slightly more specific, there's literally a document search on the website, so you just go to the document search.
That is very true. It says like forms at the top, I think, and you can just search it there.
Yeah.
Someone is asking, they have a question regarding multiple Class I felony convictions. They were convicted within the same court session.
Well, Class Is are not immediately excluded from expunction eligibility, so as long as they were non-violent, sounds like there's a pretty good chance that could be expunged.
Right. How does someone get a certificate of relief? I mean, it's kind of, it has a form, kind of like a petition. It's not a petition, but it kind of looks like one where you have to fill out the pertinent information about what the conviction was. There are certain other requirements and it gets kind of specific. And so if you are potentially interested in seeing about that, that is also a case where I would recommend reaching out to us, because it's not necessarily as straightforward as filling out a petition and submitting it. More often than not, there would also be a hearing that was required for a certificate of relief. And so if you are interested in that and seeing whether you might be eligible, I would recommend just reaching out to legal aid to see if you might be able to get some assistance.
We do a bunch of those for people that are trying to become CNAs and they have something on their record that's going to cause an issue there with the certification process. But yeah, like Lorena said, definitely contact us and we can look at it.
Yeah, I just think certificate of reliefs can get kind of,
yeah, they're
very intricate. And so definitely I would think the best bet would be just to reach out, because then someone can take a look and kind of determine the eligibility and whatnot. Someone says we were thorough. Thank you. You're welcome. Hope it was helpful. Misdemeanor child abuse. There was some substance marijuana in the child's umbilical cord. Is this considered a violent offense? That is not something that I know off the top of my head. Ryan, I don't know if you do, but
I'm not sure. We would have to research that some.
Right, we would have to look into that. So if you want to have someone look into that first.
There are certain offenses that we get asked about so much that we can tell you off the top of our head, but there's a lot of charges. So unfortunately, some of them we're just not gonna know.
Right, that's not one of them, and so we can definitely, if you want to reach out, someone may be able to kind of look into that for you to determine whether that would be disqualifying or not. I'm just getting the contact information. Next question. What is the helpline number? I'm going to put it in the chat. If you just give me 1 minute, I can put it in the chat. Someone said, better to go online or call than to show up in person. Yeah, you can't really show up in person. The way that legal aid does their kind of intake is through the helpline or the online, and then someone would either answers the phone if it's through the helpline or reaches out via online. And so I'll put both of those ways to reach us in the chat. I would try both of those ways to get in contact with us.
At the moment, there's very few people in the office to begin with.
So,
most people are functioning remotely.
Absolutely, that's right. If someone is getting records from the kiosk, I'm going to assume like if they were just to go in the courthouse and kind of go on the terminals there, what kind of information would someone need to obtain?
You need your own demographic information, name, middle name, maiden name, date of birth, just, stuff you would know about yourself.
Someone said, so we call the helpline, they can tell if we are eligible or not. Yes. That is not anything that we do in the positions that we hold. The intake specialists are usually, they're able to kind of input the information that they need, and then it will be able to tell them whether someone is eligible for legal aid services.
Yeah, I've worked in intake. I can expand on that a little bit.
Sure.
There's just a screening process to determine if you're financially eligible. So we'll go through how much money you make and your assets, and then also your case, and to make sure that there's not a duplicate case already in the system for a similar issue or a different issue. And we'll just ask, it's about maybe a 20-minute, 15-minute process of screening. It's pretty easy.
Awesome. Thanks, Niall. That's helpful because I know that's not something that either one of us do.
Yeah, we always just sit awkwardly during that question.
Yeah, we're like, someone at the intake will tell you. Sorry that we can't.
Maybe a question to ask somebody from legal aid. Huh.
Right. So, and someone said legalaidnc.org to apply. Yes, you can do it online or on there. It gives you the phone numbers too if you prefer that way. Why does the process take so long? Someone has just 2 nonviolent misdemeanors from 2017. In terms of like the waiting periods, that's just kind of what's written out in the statute, what the law is. So that's really all that we can go off of. And so that's kind of my best answer to that. Why? I'm really not sure, but
because the legislature said so.
Yeah, really, that's just what the law says. Someone asked, how can someone meet an attorney to review completed documents? Not sure exactly what they mean, like maybe if they've done it themselves.
Legal aid actually isn't allowed to do that unless we generated the documents.
Right.
I'm not sure why. It's a federal funding requirement. So best way of documents. I'm not entirely sure, honestly. Do you have any ideas?
I'm not sure either because that's not something that I would, because we kind of regenerate all of those petitions documents. Like that's kind of the process that we go in. So I'm not really sure. That might be a case for I'm not a private criminal defense attorney, but maybe that might be kind of where that person has to go.
If an attorney helps you with something, they're putting, their name on the line saying that this is good. Very few attorneys are going to want to look at something somebody else filled out and just give it an okay. They're going to want to do it themselves. Is how that will generally play out.
Yeah. Somebody said money is an issue when it comes to a criminal defense attorney. That's fair.
Again, if you qualify for legal aid and something we can help with, that's why we're here, to get around to that issue as much as possible.
Absolutely. I will put, can I put stuff in the chat? I don't know if I can.
I've never tried, but there's like a type answer button. Oh wait, you just not the QA, the general chat?
Yeah, I don't think I can. It just says hosts and panelists. I can, at the end, I will, if people want to stick around, I can share the slide again. But apparently I can't put anything in the chat where people can see it. I think only we can see it. But, okay, I'll try to figure that out. Next question. Where do we get the forms to start the process? Okay, thank you. Niall did it for me. So in the chat, Niall put the website as well as the helpline numbers and how to get to the expunction line. And so feel free to jot those down so that you don't have to go searching for them again. How to get the forms, nccourts.gov is how you can get the forms to begin. I see it. Go ahead.
I meant if I have possession of cocaine, would I have to wait 10 years? Yeah, it's going to depend on how specifically they charged you for that possession. Right. So somebody would have to look at your record to determine that, because the answer could be anything from it's never going to be eligible to it could be eligible right now, depending on how old you are when it happens. So there's a very wide possible outcome to that, depending on how they charged it.
Right. Someone asked, what petition would someone wish to file for a felony breaking and entering, if it was a conviction where they were 16 or 17 years old at the time of the offense, I'm assuming, and they completed that 10-year waiting period. I mean, again, breaking and entering can get kind of tricky. I think it depends on, for raise the age though, I'm not sure. I'd have to look at it.
My internet is
But
being slightly too slow for me to answer that question on the
I
fly.
would probably, that's again, I don't mean to be like default, but that again is probably a situation where I would advise that you reach out to legal aid to where potentially someone could take a further look at what exactly is going on there, in order to kind of determine if that conviction is eligible, and kind of if it is, what would need to kind of happen to kind of go forward. Someone said, go ahead.
Sorry. I was just saying, I think that again is going to fall into one of those depends on how you were charged categories.
Right. I agree.
I would definitely contact us.
I agree.
See if we can help you.
Can they receive a copy of the PowerPoint that lists the ineligible disqualifying convictions, I'm assuming?
Sure, we're happy to send out copies of the PowerPoint.
Assault on a law enforcement officer, I'm assuming, is that considered violent?
Yes, that
By
is.
statute, yeah, anything that has assault as an essential element is disqualifying. And so under the statute, because it has assault as an essential element, it's considered violent and then therefore likely disqualifying.
Unless they were under 18 at the time.
Right, unless that person was 16 or 17 when they were committed that offense, then that could be race age. Already answered that one.
Yep.
Again, for more specific, like, is this considered violent? I would just recommend reaching out to legal aid, and then we can kind of, if you're eligible, kind of do further research to kind of determine that. Someone, oh, and thank you, Niall. Niall also put the self-help expungement page where you can also get more information about expungement law and how, if you want to kind of go the process on your own, how you might want to do that. Someone has 3 worthless check misdemeanor charges from 2003. Said person may also have 2 simple possession drug felonies and 1 misdemeanor carrying a concealed weapon and 1 simple possession. In 2018, would they all be eligible for expungement? It depends. That sounds like there's a lot going on. So that's, again, another situation where you might want to reach out to legal aid so that someone can, because there's a lot going on, there might be multiple different kind of timeline things going on, and like want to make sure the parts are kind of going where they need to go. So could they be? Maybe. I would just recommend reaching out to legal aid, and someone may be able to take a further look at that. Does a misdemeanor larceny require witness affidavits or any affidavits along with the petition? If it's a conviction, likely.
Yeah, if it's one of the an expunction for an adult, I was gonna say an adult level conviction, which doesn't make any sense. For an over 18 conviction, any expunction for those 3 that we went over, they will require affidavits, I believe, in all circumstances.
Yeah,
I
I'm
can't
pretty
think of an
sure.
exception off the top of my head, anyway.
I can't either. So yeah, I can't either. So if it's if you're petitioning for an eligible non-violent adult conviction in any 4 of those categories, if it's an adult conviction, witness affidavits are going to be needed, along with the defendant's affidavit as well. If it's an adult eligible non-violent conviction. Pretty sure every single one of those categories, whether it's a misdemeanor or a felony, multiple or single, they all need one. Already answered that one. Is common law robbery considered a violent offense?
Yes.
Yes. Thank you. someone has charges that are like 13 or 15 years old, how do they proceed? I think it's also going to depend on what those charges are, what those potential convictions are. So really kind of, if you want to reach out to legal aid, again, I hate being the default, but that's usually the best way to kind of figure out how someone may wish to proceed.
Now, if by charges you mean dismissals, I would recommend getting rid of those ASAP.
Yep.
So, but again, reach out to us. We can, if you're eligible, we can then do a record search and figure out what's going on there.
Mm-hmm. How does someone obtain affidavits? I'm assuming like if they were to do it kind of per se. That's a good question.
Do they? We actually, I'm pretty sure on our website we have drafts of the affidavits you can download.
I didn't know that.
Or at least we did at some point. Maybe I shouldn't have said anything. All an affidavit is literally just a sworn statement. So essentially the way that the expunction statutes work with the affidavits is each of the statutes will say what it is that the person or the defendant has to swear to in the affidavit. So that's all it is. It's just a series of, you know, the defendant saying blah, 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 blah. So there's not really a standardized affidavit form like on the NC Court's website, but I want to say on our website in the expunction section, I think we have a draft example of one.
So for the previous question about charges that were 13 to 15 years old, there's some clarification that individual says they are nonviolent and some are dismissals. So like Ryan said, if something was dismissed, that's eligible today, theoretically. If it's been dismissed for 13 years, that's eligible now, depending on what the nonviolent convictions are, that would kind of determine eligibility and waiting periods and other requirements. But if they were dismissed, you could petition to get rid of those today. Would misdemeanor, go ahead.
Oh, I was going to answer the same question. I'm not sure off the top of my head with that. I think we had a question about that a little earlier too. We would have to look
about
into
what?
Oh, sorry, the misdemeanor child abuse.
Okay, yeah, that's what I was about to ask. Yeah, that's definitely one that
I forgot.
one of us
can't read my mind.
Just because, like Ryan said, there are so many different offenses. A lot of it is us just like going to the statute, reading what the offense is, looking at the like class, the level of the offense, like all of that can help determine. So we don't know off the top of our head. So I would just recommend that if you're interested, reach out to legal aid and we might be able to do some research to tell you. And someone said, is there a college in Guilford County that offers this kind of service? I'm guessing that is one in Forsyth County, but it's only for Forsyth County. I didn't know that, but I guess like other entities.
There was an event that we did with the college in Forsyth County, I think last year, that they might be referring to. We do pretty regularly. We do like partnerships with like Duke University or other universities in the area to do like expunctions, but or even with the DA's office. We've done a bunch with DA's offices in specific counties, but those aren't on like a set schedule. It's essentially just the county decides they want to do an expunction thing and contact us. So it wouldn't surprise me if there's colleges like Duke that are helping people with these like throughout the year, but we don't know that.
Yeah. And then there was just one question from Facebook, which we already kind of answered about if you wanted to go to a courthouse, you don't have to be in the county of where that, if you're looking for a particular offense or child conviction, you just need all the demographic information. Like Ryan said, you can go to any county courthouse. And if you have the demographic information, it's gonna likely pull all of what they find from all over the state. It won't find anything from any other state, but all over North Carolina, whatever fits that demographic information you put in, name, age, race, any birthday, anything like that, it should pull from all 100 counties. So you don't necessarily have to be where that person happened. Someone said clarification that kind of clinic was at Wake Forest, probably Wake Forest Law, and they did the paperwork on site.
Okay, sounds familiar.
Yeah. Okay, so that's all the questions that I see in the Q&A. I don't want to cut people off, so if you have any more, feel free to put them in. But that's kind of all that I see now. Ultimately, if you have any other questions, just feel free to apply online, call the helpline. That's honestly the best bet to kind of hopefully, if you're eligible, get more comprehensive information about what your eligibility might be and kind of what expunction might look like for you depending on current situations, circumstances, and whatnot. So I think that's it. That's all I see. So I appreciate everyone coming out. I apologize for the technical difficulties at the beginning, but we got there. And I hope you have a great rest of your day.
Thank you, everyone.
Awesome. Thanks, everyone. Thanks, Niall.
Thank you so much, Lorena and Ryan. And thank you for joining, everyone. Hope that everyone has a good rest of your day. Bye.